Hey y'all, we're back, y'all. We're back, and we're back with another reaction. Now, y'all, I'm gonna give y'all time enough to come in here because I want to let you know how much I appreciate you. Y'all, I'm gonna give y'all time enough to get here. Just a couple more little time, and then I'm gonna go ahead on and do what I do, what I always do, what I came to do, and true to do. Keep it real, y'all. Okay, y'all. Anywho, um, welcome, y'all. Happy birthday to you. If don't nobody tell you happy birthday, I will. Y'all, I want to tell y'all that thank you very much from the beginning to the end. We have hung in there from the very beginning of Julio Foolio case. If you missed a lot of it from the beginning, from when it happened, when the event took place, you can go check my channel out. I just put a Julio Foolio. I got plenty of things from years when it happened, from the beginning and now to the end. I want to tell y'all, thank you so much. It's been time when I don't knocked out. The prosecutors don't put me to sleep. Been time I done been hungry, went down there and got me something to eat. Got thirsty. Had to go to work. They were doing the time, and got up early in the morning, was tired now, and now I don't retire now. I still was getting sleepy. But and I'm glad that the mom is getting justice. Now, when y'all come up as everybody come in, these are my opinions, and my opinions all it always that's not necessary, but sometimes based on facts due to protection and allegedly said. Now, I'm glad that the mom, Julio Fulio mother, got justice for her son. Now we only speaking of what happened in this case, even regardless of what her son did, he getting justice. Uh I look at the quad, I call them the quad, Julio Fulio quad, murder trial, face penalty. Well, murder quad. Let me tell you why the reason where I use the word quad murder trial is because it's four of them, and throughout the case, to the end, at the penalty phase, psychologically, physiologically, trying to say something was wrong with them. Y'all not picking up what's going on in the physical penalty. They are trying to penalize what they did mentally. So I'm good at this, true at this, real at this. It's nothing wrong with their brains. A brain when you have memories and you can think for yourself, when you know right from wrong, when you have emotions, and it involves in your social life, physically, if you connect the three together, the triangle, three together, that's why I always say mental health wasn't nothing wrong with them boys. Now, psychologists, everybody know that something got to be wrong with you to commit a crime, shooting up a hotel, at people's cars, as if you don't give a darn, and you drove your own grandma or mother car to commit a crime, leave it, and do all of that, y'all. That's disrespectful. And you can tell who the leader. You can tell who the leader is. The leader knew who. The leader who I think would know better. Now, the leader who I think that was in control of Julio Foolio quad was trying to be allegedly like somebody up or over his head. Now you got to catch on what I'm saying. Now, if you ain't good about catching on to nothing, well, you need to sit down and try to catch it on. Okay? Because I'm not gonna put it out there like that. I'm gonna say it the way I say it. I said the control person, the controller in the courtroom is using mind control, thinking that he's using mind control to control the jury, to control the narrative. And he one of the youngest ones. Because see, the oldest two, they are already trying to say they ain't in their right mind. I'm just telling y'all what I got out of this penalty phase. Ain't nothing wrong with their brain. Their families don't did a lot. And you got one 30 years old with 4 children. 30-year-old with 4 children. Already, I know what y'all saying. But anyway, I'm already 30 and I got 4 kids. I ain't talking about you. I'm talking about one of the killers. 30 years old. And then you incarcerated and your baby mama incarcerated and your uncle incarcerated. What is going on here? It's a pattern, y'all. That's why we got to remind ourselves what we do in life matters to the young ones, our loved ones. And you have to take control of your life. You know, when y'all got to understand this is part of my major, working with young people from K to 12, mental, physically, and emotionally. Regardless of, I felt, you know what, the boys need love. Every young man in the courtroom need love, but like they lost love. They chose a different kind of love when they turn 8, 17, and 18 years old. I think I'm grown. You don't tell me what to do. Now it's time to have fun. Where is the juice? Where is the smoke? Let's have some fun. That ain't like how we do it, y'all. That's not how it goes. It takes accountability, responsibility, choices, and decisions. I wouldn't be wasting my time if I didn't love them 4 young men. Listen to your parents when you got good parents. If your parents came from a different direction, you be the first one to make another new direction. Don't worry about what's going on over here. Go this way. So in this case, with those quad individual young men in the courtroom, the controller still think he won, and he's the joker. They do what he say do. And you know, it's Sean got the right. He got the, it's Sean. Sean got the money. Money is the power. Isaiah ain't got no money, but Isaiah is a follower. That's why I'm going. Y'all young men need to separate y'all lives. Don't jump in something you ain't ready to jump into. This is real talk, true talk. When you make that decision, after 18 years old to drop over that broom and join another family, you begin to do physically, mentally, and emotionally what the other people are doing. The game is not like it used to be. You're supposed to take care of your community, not destroy your community. Y'all destroying yourselves. And when you come to the courtroom, stop all that crying. Not a tear came out your eye when you running and thinking you was in the army. You was in the army. You went to war. Those 4 guys in that courtroom went to war. Sean, Rashad, Isaiah, Davion Murphy. Y'all went to war. When y'all went to war, y'all planned that war. When you made those choices, when you sat down and made those decisions, everything that you put on the table, you weighed the possible outcome. You knew what the consequences was going to be if you got caught. You so used to getting away with and caught up with things you want to do. I've told y'all young people, once you graduate from high school, you step in the real world. It's not high school world no more. It's the real world. This when you got to choose between your goals and your future. Because it becomes the world and the law. See, even though you had laws when you was in school, you ain't in school no more. You had great families in this case with those quad killers. You have great families. Did all they can for you. You got a lot. It ain't always got to be coming from no bad family. No, I don't call it no bad family. Dysfunctional family. But it came from a behavior that you decided you to pick up. It's no way a man 30 years old should be out there shooting on a machine gun like he ain't got no guidance, like he ain't no daddy, like he ain't got no responsibility. All of you worked it. Y'all worked somewhere, but guess what? You want stuff free. You want stuff like this. This ain't no bewitched. This ain't no I dream of Genie. You wasn't young. You wasn't old and invisible man. You can't, you got to go do what you got to do. Go work, go to school, go to work. Get a job with benefits. All the restaurant got benefits. I seen a lady, she's a older lady now. She was working at Red Lobster with the benefits for years, just waiting. Just being a waitress, not a cooker, not nothing else. She was waiting people. You know that lady making money out. Why you laughing? Why you picking at people? That's what you could have been doing with 4 children. Rashad Murphy. 4 babies. And the first thing y'all do when you need help, when you come in the courtroom, when you want them to take the stand, is the grandmas. Every young man in that courtroom either had a grandma up there or either somebody who been trying to talk to them for the longest, who love them, they favorite uncle, they mama, they grandma, they sisters. People that all I hear, they love y'all. But you decided to choose your route. And you got to deal with the consequences. Ain't nothing wrong with your brain. Of course, your brain gonna be dysfunctional. Went from the start, from the beginning. It ain't got nothing. Your IEP is under control. You weren't thinking about that when you was in the interrogation room. Y'all didn't have no remorse. Y'all were there trying. Sean was still trying. Sean got the right, was still trying to get away. Still trying to escape. Don't work like that, y'all. It don't work like that. You have been identified. You have been convicted. Now you about to be sentenced. That's your choice. That's your decision. I'm not gonna feel sorry for you. You didn't cry when you did it. Ain't no use in you cry now. Go do your time and find your new family while you're in jail. Continue to read the Bible. Continue. I don't see how anybody listening to you and you just took a man's life. I ain't no man in the world. You talking about you preaching to other kids and stuff like that. And you took Julio life. Y'all stop listening to the people who misleading you. No, you need to be listening to them. See, what Gathright wants to do is still take control while he in jail. And they better watch him. They better watch him. Better watch him. If he try, you better watch him. You don't know what he teaching them young boys. He don't need to be around on y'all. Keep showing in there with them grown men. He think he grown. Keep in there with the grown men prison. Don't divide them. Don't take them out of that prison. Let them stay there. They scared. That's what they try to do. Still escape. Because they know what's inside of that prison. They know what they got to deal with. That's what you want them to do. Deal with it or don't deal with it. Start transferring them. They don't need to go nowhere. Mentally, nowhere physically, not emotionally. I'm not feeling sorry for them. They don't hurt their family lives, their children lives, if they got kids. And they don't effed up their own lives. So you made those decisions, those choices, and deal with the consequences. And don't be mad at nobody. Don't be mad at the jury. Mad at yourself. It's too late, young people. Once you done made the wrong choice and decision, you cuss your grandmama out, you disrespect your grandparent, and they always there for you. They there for you when your mom and dad ain't there for you. Oh yeah, especially grandma, they're gonna stick with you. They're gonna stick by you, but they want you to do right. Now you asking for granny help. Now you asking for your grandmother help. Now you asking for your grandmother help, the one you disrespected. You even clean your grandmama car off, Sean. That's why, you know what? I ain't never thought my kid was no killer or nothing like that. But when they were young, I said, look at him. Take my car straight to that store. I know what time you're supposed to be there. I know what time you left here. Don't take my car nowhere else. When they be done made an extra stop, y'all, inside of your car, you'll know where your car been. Check the mileage out. It's a tracker in the car. You took your own grandmama. Your grandmother, man. If you take a grandmama car and you commit a crime in your grandmother car, son, you'll do anything to anyone, and that's what you did. You don't give a darn. I ain't gonna cuss. I don't have to cuss just to make you understand. Y'all, this young man took his grandmama car, wiped it down. And here go your car, grandma. And that's how you appreciate your grandmother who took you in when your mama and them was in the army. Sean, this is ridiculous. See, you escaped when you said that your daddy did this. Your daddy wasn't doing nothing but discipline you because he loved you, because he didn't want to see you get in trouble like you did. Now, it's a difference between an abuse and discipline. Y'all getting these words effed up. They discipline you because they love you, not hate you. So you won't get into what you got into. Look what you into now, Sean. But you blame your father when he was trying to be that daddy for you, when he was trying to be that man for you, when he was trying to teach you. And look where you found out. You ain't no 20 years old. You still fresh out of high school, boy. We teaches you all this in health, prevention, preventing, preventing choices and decisions. Now, y'all, I'm gonna go ahead on. Ain't nothing wrong with these boys' brain. They got somebody else in there talking about their brain. Of course, my brain ain't gonna be right now because I'm scared for my life. Young people make good choices, okay? Get out the I don't care mode and get your job. Job. If you're gonna drop out of school, get your job. But you ain't about to get no job like mine, what I had. You got to go to school like I did and sit in them classes. You ain't gonna get a job, big old job, making the big old money like your uncle did, or like them. It ain't that easy. But you can get a job as a manager and grow and own your own business. You can get your own business and come up. But ain't nothing free, baby, and it ain't nothing easy. If you don't trip and fail, let me tell you something, and I'm gonna let y'all. We're gonna go on to the. I'm just think about them young boys sitting in that courtroom, y'all. I'm so proud. I am so blessed that I was the mother that I was to my three girls and two boys. The two boys are youngest. The youngest one is 30. I got on their butts. I talked. I did more talking than anything. I ain't stopped talking. And they have to tell me now, Mama. I da 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 da. I said, but I'm still Mama. I'm still Mama. I didn't give up on y'all then. Why I'm gonna give up on y'all now? So they doing good. Just because mamas, mothers, fathers. But see, the reason why I said mama, because that's who they gonna call. The principal gonna say, call your mama. Call your mother, call your father, call your grandmother, call someone. But when you talk about reality, call your grandmother. Call your grandma. Where's your mama? If they act like they don't understand, if you say, where's your mother? Where's your mama? You got to switch up on the English with these young people, y'all. I used to speak, woo, Lord have mercy. Anywho, let's get in the courtroom. Now, y'all, let's see what they wearing today. And y'all know who my favorite one out the courtroom, and that's Davion Murphy. Look like a big baby that need a hardcore person on him. He's a lot of work. I couldn't deal with him, but I like him though. In the courtroom, I don't like him to be nothing else. I don't want no. I talk about liking to go with him. No, I see something, a big old baby. Used to have in their way, y'all. That's all they used to have in their way. Now, prosecutor, I took me a nap. I just woke up. Just be with you. Here we go, y'all. Isaiah Chance are the CCP and criminal gang member. Okay. The aggravating factors for Sean Gathright are contemporaneously convicted of a felony involving the use of violence. I guess it's use of violence or threat of violence. I just said use of violence because I don't know. That's fine. What's actually used. Right. Okay. Great risk of death to many persons, and then CCP. Okay. And then the next, the aggravating factors as to Rashad Murphy, contemporaneously convicted of a felony using violence. Great risk of CCP and criminal gang member. Okay. Then as to Davion Murphy, contemporaneously violence, great risk of death to many persons, CCP, criminal gang member. All right, and then the rest of that instruction is just taken from the standard. So I'll be looking for typos and anything along those lines, but you guys need to be doing that as well. Other than that, it's just taken from the standard instructions. As to Isaiah Chance, the mitigating circumstances. Sure. Yeah. I'll clean that up. Or my judicial assistant who's more computers. Somebody will clean it up. Okay, so as to Isaiah Chance, the statutory mitigators, age and time of the offense, and no significant history of prior criminal activity, correct? Yeah, the existence of any other factors. Yeah, that one's always left. So, but I do have that one. Okay, and so then your non-statutory state. Looking at these, do you object to any of the non-statutories? I can tell you the only one I had a question about was Isaiah Chance was convicted as a principal. Yeah, so I don't know. Yeah, I'm gonna stop it right quick. Something that this attorney doing is so unprofessional to me. Maybe it's me, or just I always had respect for young people. You know, even when I was young, when I was used to be a substitute teacher, I want to be like 23. She's older. It's what she look like she shouldn't be doing. She's sitting beside Davion Murphy. This is so unprofessional. Where she got the laptop sitting there, and Davion sitting there, a young man, and she gonna take a can and drink a can. This is so out of place to me. She got this that laptop sitting on her lap, and he looking down at the laptop. That ain't professional, y'all. I guess I learned professionalism from the job. I ain't on the job now, so I ain't got to be like that no more. That is so unprofessional. Look at it. Look at it. She got a can in her mouth and a laptop sitting on her lap, and Davion looking down in her lap. That so unprofessional. Put the lap. You know, Davion looking at the laptop. Sit it up on the desk. Sit the laptop on the desk and put that can down out your mouth because that don't look nice on TV. And act like you dealing with a suspect. And his life is on the table. Take that laptop off your lap and put it on that table so Dave Young can look at your laptop. You don't want to look at it down there. That's not nice. I'm just saying that's just me.
Yes. I don't know. I've got a question mark about that one. Well, I understand, Your Honor, but it's a fact of the case. Double states scenario case. No alternative theory.
Then she go look at David Young. Y'all see that?
So I'm sure that is correct. I just think that there's a different way to word it, but again, it's their litigation. I'm open to a different way to word it. I was trying to. I understand. Word it in a way that's actually accurate. Well, I mean, maybe I'm just throwing this out there for consideration. Maybe something like expensive equipment. Watch this. Riverside turns phone recording into social clips automatically. It even creates thumbnails and writes the description, so I can post fast without getting overwhelmed. They're just charging a fire alarm. It's not convicted of that. So, you all think about it. We don't need to make that decision at this moment, but I'm just going to put a question mark on it. I reviewed all of them, and I can have an objection to the rest. Okay. All right. Mitigating circumstances as to defendant Sean Gaffrey. Any objection to any? I did have an objection to one of his. Number 4, Sean Gaffrey has a juvenile brain. He's not a juvenile. Well, there has to be evidence to support it. What's the evidence to support it? Based on an officer's testimony and his expertise working with the juvenile system and how they were categorized. An expert in the area concerning the mental health or the development of something as an expert. Yeah. This is an adult crime. I mean, they have the statutory that is 18 years old at the time of the test is fine, but again, I don't think that there is evidence to support that he's a juvenile brain. I'm gonna grant the state's motion. That one. I don't think there's evidence to support it. Number 1, there was a typo. It has more than one prior. Oh, okay. Thank you. Okay. State any other objection to any of the other mitigators by Mr. Gaffney? Okay. And that also has format issues that I just clean up. Someone? Okay. As to Rashad Murphy, let me take a look. The statutory mitigators, I wasn't sure. Mr. Gonzalez, I had has no significant history of prior criminal activity, and that I didn't. You do have in here the defendant was only 30 years old, but are you also asking just for the standard Rashad Murphy's age at the time of the offense?
Yes, Judge. And I don't see when the court's referencing the 32-year-old statement. Are you seeing that somewhere?
I am. So I got a list of the proposed mitigators from Mr. Hernandez. You know what? I was looking at those. Sorry, I printed out the ones that were sent by you. Right, at the time. So all I had in PDF form was Mr. Hernandez. So I'll just read them to you. Okay, so I put in. Yeah, that's fine. So I put in the statutory mitigators of no significant history of prior criminal activity and Rashad Murphy's age at the time of the offense. Mr. Hernandez is also asking that the defendant was only 30 years old when the homicide occurred. The defendant has a history of physical, sexual, or emotional abuse as a child, consistent with childhood post-traumatic stress disorder.
Sean, you were 30 years old when this happened? 30 years over 30 years old is when you already have established your life, Sean. And you got four children. You got four kids. If you wanted something to do, you could have got a job and then just spent all your years with them. Besides out there in the streets, hopping around fence in a hotel and running from the police. If you wanted something to do, you had something to do. You got four kids, Sean, at the age of 30. If you got that bored in life, you could have got a job and did something, just continue taking care of your kids.
I've never heard anything about sexual abuse, but maybe I missed it. Um, Three, the defendant has maintained a loving relationship with family and friends while incarcerated. Four, the defendant has displayed appropriate behavior and the ability to follow rules while incarcerated. Five, the defendant has developed religious and spiritual awareness while incarcerated. Six, the defendant helped raise his younger siblings, including work. Seven, the defendant loves his children and has been a father to them. As a minor, was
What?
removed from his parents' home and placed into foster due to negligent and abusive situations in the primary home. And then nine, the defendant has no prior felony convictions. Also fine.
Mm.
Yeah, I didn't hear any testimony about sexual abuse, physical and emotional, even actual abuse.
I, the wording I said is more, but I agree that there was no sexual.
So the defendant has a history of physical or emotional abuse.
I would agree with that.
Okay. Okay, that's fine. So I'll put those in. And then the last one, as with all of them, the existence of any other factors. And then as to Davion Murphy, as far as the statutory, yeah, I wasn't sure about that. So you all are requesting that the capital felony was committed while Davion Murphy was under the influence of extreme mental or emotional disturbance, correct? Okay, so I'll put that one in as a statutory. The capacity of Davion Murphy to appreciate the criminality of his conduct or to conform his conduct to the requirements of law was substantially impaired. The age of Davion Murphy at the time of the offense, um, existence of any other factors. Davion Murphy suffers from traumatic brain injury. Davion Murphy was exposed to repeated violence in his childhood and young adult life. Davion Murphy is in the borderline range of intellectual disability. Davion Murphy grew up in a household marked by instability and financial strain. Davion Murphy did not have a stable male role model in his life. 10. Davion Murphy's father was diagnosed with schizophrenia. 11. Davion Murphy's father was incarcerated for life when Davion Murphy was 12 years old. Any objection to any of those? No, Your Honor. Okay. All right, so I'll put those in. And then the existence of any other factors. Okay. All right. So then I included weighing the evidence, looking at the factors. Any objection to the 9 factors? I did include that defendant Sean Gathright has become a witness in this case and should apply the same rules to consideration of his testimony. You apply to the testimony of other witnesses. And I did include expert witness. I left in law enforcement. Anyway, any other changes to weigh the evidence 3.9? Defendants Isaiah Chance, Rashad Murphy, and Davion Murphy each exercised a fundamental right by choosing not to be a witness in this case. We must not view this as an admission of crime or be influenced in any way by this decision. No juror should ever be concerned that a defendant did or did not take the witness stand to give testimony in the case. Any other requested edit to the defendant not testify. No, you're okay. Next up is the criminal gang member definitions. And that was the same as the one in the guilt-based instruction. I'm going to take out the definition of associate because it doesn't apply in those cases. Any requested other changes or edits to that? Okay. Rules for deliberation. Can be a factor. So are there any other of the factors anyone's requesting under 3.10 rules for deliberation? Okay. Cautionary instruction 3.11. Submitting case to jury 3.13. And that's it. Okay. So are there any other requested instructions as part of the final set of penalty phase instructions?
Yeah, I just have one point that I wanted to clarify.
Sure.
Regarding the mitigators, I just wanted to make sure that number 2 read the defendant as a mistreated physical and emotional abuse.
Yeah, that's fine. I can do and or. Want it to be and?
I would prefer and.
Sure. All right, hold on. Not what I did. So, I guess Ms. Finkelstein, if you had a chance to review the proposed final. I emailed them out last night. Attached to that should have been the instructions. The same email. Okay. So let's just go over the aggravating factors as to Isaiah Chance are the CCP and criminal gang erroneously. I guess it's use of violence or threat of violence. I just said use of violence because I don't know. That's fine. It was actually used. Right. Okay. Great risk of death to many persons, and then CCP. Okay. And then the next, the aggravating factors as to Rashad Murphy, contemporaneously convicted of a felony using violence. Great risk of death to many persons, CCP, and criminal gang member. Correct. Okay. Then as to Davion Murphy, contemporaneously convicted of a felony involving violence, great risk of death to many persons, CCP, criminal gang member. Right? Okay. the rest of that instruction is
the instant remedy to stop snoring without changing your sleeping habits. Most
you guys need to be doing that as well. Other than that, it's just taken from the standard instructions. As to Isaiah Chance, the mitigating circumstances. Sure. Yeah. I'll clean that up. Or my judicial assistant who's more computer savvy. Somebody will clean it up. Okay, so as to Isaiah Chance, the statutory mitigators each time the offense and no significant history of prior criminal activity, correct? Yeah, the existence of any other factors. Yeah, that one's always left. So, but I do have that one. Okay, and so then your non-statutory state. Looking at these, do you object to any of the non-statutories? I can tell you the only one I had a question about was Isaiah Chance was convicted as a principal. Yeah, so I don't know. Yes. I don't know. I've got a question mark about that one. So that is correct. Well, I mean, maybe, and I'm just throwing this out there for consideration, maybe something like, think about, he was not convicted of carrying, possessing, or discharging a firearm. He's not convicted of that. So, you all think about it. We don't need to make that decision at this moment, but I'm just going to put a question mark on it. Any other state that you have an objection to? I reviewed all of them, and I didn't have an objection to the rest. Okay. All right. Mitigating circumstances as to defendant Sean Gaffray. Any objection to any? I did have an objection to one of his. Number 4, Sean Gaffray. Brain is not a juvenile. He's charged as an adult. Well, there has to be evidence to support it. What's the evidence to support it? Based on officer's testimony, I think that's what he's working with juvenile system, how we were categorized. Yeah. Statutory that he's 18 years old at the time of offense, which is fine, but again, I don't think that there is evidence to support his outbreak. I'm gonna grant the state's motion to strike that one. I don't think there's evidence to support it. Number 1, there was a typo. It had to work more prior criminal. Oh, okay. Thank you. Okay. State any other objection to any of the other mitigators by Mr. Gaffray? No, Your Honor. Okay, and that also has 4 remedy.
I'm gonna skip it, y'all. Okay, let's go to our first witness. Okay.
Okay. All right, you ready to go, Mr. Harmon? Okay, let's bring in our jury.
All right.
Okay, very good. Welcome back. Everyone have a seat. Welcome back, members of the jury. I do know that one of you has got a special event this evening, so I promise you we will break before 5. Okay, not to worry. All right, very good. State, you wish to call witnesses.
Yes, Your Honor. The state of Florida called
Good morning.
Would you please state your name?
My name is Tony T-O-N-I-A Warner Floyd at Meridian Healthcare in Gainesville, Florida. It's a community mental health care center.
Okay. And what do you do there? What is your position?
I am Vice President and Chief Medical Officer.
tell the jurors your educational background?
Yes, so I graduated from the University of South Florida with a degree in chemistry. I then graduated from American University of the Caribbean with a medical degree. I did my psychiatry residency at Connecticut Valley Hospital in Connecticut under the auspices of Yale University. That was 4 years of training in general psychiatry. I then came to Florida and did a 1-year fellowship in forensic psychiatry at the University of Florida.
And stronger than value. And can you, from that point, take us through your work?
Yes. So at that point, I was asked to stay on faculty at the University of Florida, and I remained there for 18 years on faculty at UF until I retired from there in 2015. And at that point, I was the vice chairman of the Department of Psychiatry, the chief of the Division of Forensic Psychiatry, and the head of the Forensic Institute at the University of Florida, officer at Meridian. And we provide primary care service for North Central Florida, mainly for individuals who are underinsured.
Or considered primarily a clinical practice?
Yes.
Okay. And do you also do consultations in the forensic area?
I do.
And doctor, do you hold any board certifications?
Yes, I'm board certified in general psychiatry and in forensic psychiatry through the American Board of Psychiatry and Neurology.
Can you just explain, if you could, to the jurors the process to obtain your board certification?
Yes. So in the past, we had to do a written examination and then an oral examination for the general boards. And then the forensics boards was just a written examination. Now it's changed, and I think every 3 years we have to do update, do some testing, read some general articles, some testing, and you can opt into that program and do some peer reviews and have peers review some of your work, or you can still do the test every 10 years to maintain your certification.
Are you licensed to practice medicine here in the state of Florida?
Yes, sir, I am. I have been licensed in the state of Florida since 1998.
Prior to working here in Florida, did you work or do forensic evaluations in another state?
I did. I started my forensic work in 1996 in the state of Connecticut while I was at Yale University.
Are you a member of any organizations or societies that deal with forensic or general psychiatry?
Yes, I'm a member of the American Psychiatric Association and the Florida Psychiatric Society. I'm a past elected president of the Florida Psychiatric Society. A member of numerous different committees for the Florida Psychiatric Society, including presently at the chair of the Ethics Committee for the Florida Psychiatric Society.
Can you explain to the jurors what the field of psychiatry deals with?
So psychiatry basically deals with brain diseases that affect how an individual thinks or behaves.
And the subfield of forensic psychiatry, what does that area of medicine deal with?
So that area deals with anywhere where psychiatry intersects with the law, whether that's in a criminal case such as these or in the civil arena, personal injury, contested wills, any number of areas in the civil arena.
Can you explain to the jurors the difference between psychiatry and psychology?
Yes, so a psychiatrist has completed medical school, such as myself, and can prescribe medications and a psychologist has a PhD or a PsyD. They have different stipulations with regards to psychologists, but they can prescribe medications.
Your work as a consultant in forensic psychiatry, how long have you done that here in Florida?
Since 1998.
Since 1998. Okay.
Yes,
Would that be generally when you came here?
Correct.
And through that part of your practice, do you consult on, well, you obviously consult on legal cases. Do you consult on both civil and criminal cases?
I do.
In criminal cases, can you tell the jurors the type of issues you deal with?
Yes, so the majority of them are probably competency to proceed. That's very common. So do they understand the court process and can they assist their attorney in going forward with their case? Do they understand their charges? I also do sanity at the time of the crime. I have done also competency to be executed. I've done those for defense and been appointed by the governor to do those.
And are you, in fact, appointed by the governor to a board of psychiatrists to perform those competency evaluations?
Correct. There's a committee or board of 3 psychiatrists appointed to do that when that happens. Correct.
Have you previously testified in a courtroom like this as an expert in the area of forensic psychiatry?
I have. Yep.
This is the quickest clear out stuff poop. You've never had to yell, yes, I know I've been on the toilet for hours.
Side commercial.
Numerous times. Probably hundreds.
Okay. And in what jurisdictions?
From Key West to the Panhandle, like all over the state of Florida, New York, all of it down the East Coast, Connecticut, all of it down the East Coast, basically.
And have you appeared on behalf of the state of Florida in a situation like this before, or been consulted by the state of Florida in a capital murder case and thus by the penalty phase proceedings?
I've worked for the prosecution and the defense in cases just this.
And that was my next question. So you have worked, that's okay, you worked on both sides of the border.
Yes, absolutely.
Cases such as this, when you've been retained, in this case you were retained by the state of Florida, are you provided materials and will you seek out additional collateral materials?
Yes.
Why do you do that?
And you want to have as much information as possible. If something's missing, I didn't see or I didn't have access to, I'll ask for that. And I did that in this case. Mentioned some things that I saw in Dr. Eisenstein's report that I didn't see. So, inquired about those. So, yeah, you want to have all that you can have to be able to formulate your opinion.
Okay. And what would be the benefit of looking at law enforcement reports, police reports, interviews of the person being evaluated?
All that has to do with the individual's thought process, their adaptive functioning, what they're doing, how the whole process, what went into, the instant events, and that's why we're involved in the first place.
In this case, were you provided materials by the state of Florida?
Yes.
And did that include law enforcement reports dealing with the investigation, in this case, from the Tampa Police Department?
Yes, it did.
Did it include investigative reports from the Jacksonville Sheriff's Office?
Yes, it did.
Did it include audio-video evidence of both the crime scene areas and places within the city of Tampa before and after the crime scene, and audio-video interviews?
Yes, there were also photographs.
And photographs.
Correct.
Were you also provided with the medical examiner's report in this case?
Yes, I was.
And I believe some of the autopsy photographs.
Yes, there were autopsy photographs. Correct.
Were you provided, doctor, with social media and cell phone extraction evidence?
Yes, I was.
You've already mentioned you were provided with Dr. Hyman Eisenstein's report.
Yes, that's correct.
And were you provided with a transcript of the deposition that the state of Florida took of him?
Yes, I was.
Were you provided with a transcript of the deposition of Dr. Tracy Hardy?
Yes, I was.
Have you conducted some type of evaluation of both defendants Davion Murphy and Isaiah Chance?
Yes, I did.
And did that involve you meeting with them by Zoom, I believe?
That's correct.
And is that a practice that you have done in other cases?
Yes, absolutely.
Now, by Florida statute, your evaluations of these two defendants is a prohibitive evaluation until they are convicted of capital murder. Is that correct? I can rephrase.
Okay.
Are you pre-trial or before the trial starts? Do you have access to interviews or evaluations of defendants?
Go ahead. I do not.
And in this case, did your evaluations of them occur after the convictions occurred?
Yes, it did.
And is that by law?
That's correct.
Okay. So once Mr. Murphy and Mr. Chance were convicted of capital murder, first degree premeditated murder, you were then given access to be able to conduct evaluations.
That's correct.
And when did those occur?
They occurred this past Saturday.
All right. So that would have been the day after they were convicted.
That's correct.
And did that take place throughout the day on Saturday?
Yes, it did.
So I'm going to start with your meeting with Davion Murphy.
Yes, sir.
Before we get to that meeting and evaluation, you have talked about some of the items you were provided. Were you provided with Dr. Eisenstein's report?
I was.
Were you provided with numerous documents and records that were provided to the state from the defense?
Yes.
And did that include educational records?
Yes.
And recently, have you been given information concerning medical records?
Yes.
In your evaluation of him on Saturday, can you tell us how long you met with him?
So I met with Mr. Murphy for approximately an hour and 20 minutes.
And what type of evaluation did you conduct?
So I did a forensic evaluation, so getting just general getting to know him, and then a mental status examination.
The forensic evaluation, what does that consist of?
So it consists again of, so initially I introduce myself, the purpose of the evaluation. I let him know that it's not confidential the way that it normally is when you meet with a psychiatrist, because we're doing it for the court. I'm going to have to take notes and that I'll be asked to test. If you ever wanted to start your own clothing brand, but you didn't want to buy, the things that we talk about are not going to be private. Make sure that he has an understanding of that, and his attorney was present at the time as well, via Zoom. And then I go through kind of his history, talk to him about his family, growing up, his educational background, work history. So just get a good, feel for him, a good background on him. I do all of that, go through his medical history, his psychiatric history, substance use history, and then do a cognitive or mental status examination.
So I'm going to start with your discussions with Mr. Davion Murphy about his family and his upbringing. All right?
Yes.
Did he give you a general description of his childhood and growing up?
Yes.
What did he tell you?
So he talked about his family growing up. He loved his family very much. He described his childhood. He was Christian. He attended church. He was very God-oriented. He was very close with his family. He enjoyed his childhood.
Um, did you have an opportunity in the last couple of days to watch testimony of Dr. Eisenstein and also to review the testimony of Dr. Martin?
Yes.
Okay. And you have Dr. Eisenstein's report, you said?
Yes.
Okay, all right. Did you, in your investigation of this case, your investigation and your discussions with Mr. Murphy, did you determine if there was any history of physical or emotional abuse?
He denied that to me. I specifically asked him about physical abuse and sexual abuse. He denied that.
Can you talk to us in a little more detail about your mental status exam and exactly what you did with it?
Yes. So with my mental status examination, I go through and just kind of notice their appearance. And he was dressed in orange correctional attire. His motor behavior was within normal limits. His speech was within normal limits. There was no kind of latency of response. So it didn't take him a long time to answer. When I asked him a question, there wasn't a long pause between his response and my question. He was oriented to person. He was able to give me his date of birth, his age. He was oriented to the date, the day of the week, the season. He was aware that he was in the jail on Falkenberg Road, so he was oriented to where he was. He knew that Mother's Day was the following day, so he knew the upcoming holiday. So he was well oriented to what was going on and where he was at. I tested his concentration. I gave him 3 items to remember for me. He was able to register them and give them back to me right away. And after a period of distraction, so after I do all these other things I'm going to tell you about, I asked him about them again. And I had given him the words orange, tree, and flower. And at the end of all these other things I'm going to tell you about in a second, he gave me back orange, plant, and flower. So very close. The middle one, instead of tree, he gave me plant, but he was very close with those. He was able to identify the current president, and then he couldn't recall Biden, but he said he was an old white dude, described him as an old white dude, quote unquote, and then knew that there was Trump and Obama and Bush again. So he was able to kind of name some presidents. He spelled the word world correctly forward and in reverse, which is again a test of concentration and a test of spelling. And so he knows his alphabet. I know that was an issue and a question. Another test of concentration, I had him do serial 3 subtractions from 20. So I said, can you start at the number 20 and go backwards by taking away 3s? And he went right down, 17, 14, 11, 8. Went right down, no problem. Through 6 calculations and clearly retained the task that I had asked him to do. He did a simple calculation. I asked him if he had $20 and gas was $4 a gallon. How many gallons could he buy? And he said, buy 5 or 6. He knew the general information. I asked him, what's the function of your stomach to digest food? If you were to leave Jacksonville, which direction would you travel to go to Miami, New York, California? He got all of those correct. Who's Martin Luther King Jr., Black leader who fought for freedom? And then I do abstract reasoning. So just testing their ability for abstract thought. How are a dog and a lion alike? He said animals. How are an orange and a banana alike? Fruit, a coat and a suit, clothes, a table and a chair. And that one he said, I don't know. And then he said to sit and eat on. So that one he gave a very concrete answer and gave me kind of how they're used as opposed to the correct response would be for treated as how they're alike.
American dentist, and the problem starts right here in the back.
Proverb, which is what goes around comes around, and his response was response was a concrete response. And then this is when I went back after answering all of those questions and asked them, do you recall those 3 words? So after I gave him that, all those distractions and all that, went through all those, that's when he was able to pretty well recall those 3 words. So he did very well, pretty well, on the mental status examination.
And how many times have you administered that examination?
Back in the 1990s.
So hundreds, thousands of times?
Absolutely.
What about just conducting a mental status examination? How many times have you done that with patients in a clinical setting or examining in a forensic setting?
Oh, many, many more times than that.
Okay.
I mean, I saw patients this morning on telehealth people hotel.
At Meridian?
Correct.
Okay.
Yes, sir.
Did you detect in that evaluation and in your entire evaluation anything to suggest that Mr. Davion Murphy has any kind of impaired brain function or damage?
I did not.
Have you ever dealt with patients or people in the forensic setting that do have brain damage or have suffered traumatic brain injuries?
I have, yes.
And so you would know how to detect that, or is that something you're trained to do?
Yes.
Have you covered everything that you've done with him in this evaluation, or is there more?
No, that's
pretty much it?
yes.
Okay. Now, in your having conducted your mental status examination and your forensic evaluation of him and your review of the materials in this case, I want to ask you a few questions.
Yes, sir.
And specifically, you reviewed the facts of this case
Correct.
and witnessed and saw the video from the offense itself and how it was executed, the crime,
I did.
the murder.
I did.
I want to ask you, do you have an opinion as to whether the capital felony in this case was committed while the defendant was under the influence of extreme mental or emotional disturbance?
I did not see any evidence of that now.
And do you have an opinion as to whether the capacity of the defendant to appreciate the criminality of his or her conduct, his conduct in this case, or to conform it, his conduct to the requirements of law, whether it was substantially impaired?
I did not see any evidence of that. No.
Now, did you come to any opinions about Davion Murphy's level of cognitive functioning?
Yes.
And when you arrived at that opinion, did you consider the testing that you did or the evaluation?
Yes.
Did you also consider questions that you asked him about his history? Let me ask you this, did you talk to him about his work history?
I did.
What did he tell you about his work history?
So he has held numerous jobs in numerous different places. Specifically, a lot of them were in the food industry, working at different Burger King, IHOP, different places, which required a lot of kind of fast kind of thinking and fast doing. And he was there for significant periods of time, 6 months, different significant periods of time. And some of them overlapped where he was working at 2 to 3 different places at a time.
Did he relate to you that at some point he had moved to Orlando from Jacksonville?
Yes, he was residing with a girlfriend in Orlando for a period of time.
All right,
Did he
Davion.
relate to you something about the expense or cost of living there?
Correct.
And did he inform you as to maintaining multiple jobs due to the cost of living?
Yes.
And you mentioned some of the duties that he did. As far as a couple of the places he worked at, I think specifically IHOP and JD Steak and Shake, did he advise you that he worked as a short order cook?
Yes.
And would that be a position that has a timed element to it?
Yes.
Is that something you considered?
Yes, absolutely.
All right. And these things that we're discussing, would those be considered adaptive functioning.
Yes,
Now, you're familiar with the DSM-5?
I am.
Do you have a copy of it with you right there?
I have a copy of the DSM-5-TR, correct?
Okay, now that's the current edition, correct?
Correct.
All right. Is that a statistical manual that you utilize frequently?
Yes.
And in the DSM-5-TR, are there not recommendations when assessing, as a psychiatrist, when you're assessing for cognitive functioning or cognitive ability to look at adaptive functioning?
Absolutely, it's a requirement. Correct.
All right. And it's specific. Only broadcast brand-wise. It is stronger than any other brand. If you didn't,
What I'm
know
gonna
what
do,
that is or what
I'm gonna speed it up a little bit, y'all. I'm gonna try to speed it up to his attorney. Here we go.
Diagnosed with adjustment disorder. Correct. And disorder. One's development of emotional or behavioral symptoms in response to an identifiable stressor has occurred. You've identified that stressor as him facing these charges and being incarcerated, right? Correct. That's the stressor. But isn't it true that that person's response to that stressor must be out of proportion to the severity of it? Yes, but he's been diagnosed with symptoms and started on medications. So how are you, I mean, if somebody's stressed because they're facing the death penalty, right? Yeah. His stress is not out of the norm, correct? Correct. But you still consider that that he suffers from or you diagnose him with adjustment disorder? Yes, because I think it's in relation to that stressor, absolutely. It's a significant stressor, I agree. Well, how is his behavior out of proportion to that stress? I don't think his behavior is out of proportion to that stress. I think he has emotional, issues. I think it's in response to that stressor. But it's not out of character. Correct. And if you read in the beginning of the DSM, it's not designed to be used in a cookbook fashion, so it's not designed to be used by people who aren't trained to use it. So you can't take every word like you're taking it and apply it. That's what the DSM. Yeah, but it also says it's not designed to be used in a cookbook fashion by people who aren't trained. I'm not claiming to be trained. Well, that's right. Right. And so I'm using it. Okay. And not in a cookbook fashion. I believe he has adjustment disorder. So tell me how Davion Murphy is acting out of the stress of being potentially executed by the state of Florida. You can answer one more time. Go ahead. I don't believe it's out of proportion. I think it's a significant stressor. And I think that he has symptoms in relation to that significant stressor, and he's being treated for them. And so that's the most appropriate diagnosis according to the DSM-5-TR. And again, there's a section in the beginning of the book specifically relating to forensics, and it says specifically it's not to be designed to be used in a cookbook fashion. You have to be able to apply it using experience and training. And what was your other diagnosis? I gave him antisocial personality disorder and then the substance use disorders. And what is the criteria for one to meet that diagnosis? Which diagnosis? Antisocial personality. Right, so he has to have 3 of the 7 criteria. So disregard for lawful behaviors, deceitfulness, lying, impulsivity, aggressiveness, lack of remorse. Those are all things that are in his history. He has to have had conduct disorder, met the criteria for conduct disorder as a youth, which he did, having met over 3 of the 15 criteria for that disorder.
Was he diagnosed with chronic disorder when he was young?
No, but he met the criteria for it if you go through his history.
But he wasn't diagnosed with that.
No, but he met the criteria for it when you go through his school records and his history.
And part of this criteria is that the person has to repeatedly lie, right? Part of that is being deceitful and repeatedly being deceitful, lying all the time,
Correct?
conning others for personal profit, using aliases.
That can be some of them, yes.
Do you know of any times where a younger has used an alias or has conned others for profit?
No, and I don't believe that I use those as
And impulsivity is one of the criteria, right?
correct.
Failure to plan,
Failure to plan ahead, correct.
failure to plan ahead. Involvement is failed to
Just with regards to failure to plan ahead, where you're going to live, kind of adult behaviors and kind of planning out your life, buying a house, how you kind of live through your life and planning your life ahead. So not getting into trouble, getting through some.
This is everything that I spoke about at the very beginning of my live. I knew this was going to come up. Same thing that I spoke about. Their behavior, y'all. This physical, socially, and emotionally. They plan. Nothing wrong with them. She trying and claim that he kind of faked a little bit. This now came up numerous of time in day 3 that they try to claim that he faked his psychological disorders. Allegedly.
So those are the behaviors that it identifies as planning ahead.
But she also put a lot of time and effort.
So Sean, what's she trying to say? Davion, like I said at the beginning, know how to plan. He know how to plan what he's gonna do. Now it's strange how these different psychologies, they got different psychologists. She's supposed to be a forensics. She did a forensics evaluation on him. Not confidential. And he passed.
There are the state's police reports and videos and things of that nature, right?
Correct.
Right.
That is 24/7 emergency and
Oh, Lord have mercy. I never did this with all these commercials.
And if someone is diagnosed with that personality, they are impulsive and they don't plan, right?
No, that's not true.
That's not part of the diagnosis.
It's impulsivity and failure to plan ahead with regards to their life and not with regards to one specific crime or incident. I think you're trying to kind of narrow it down to the instant offense as opposed to evident with regards to, lawful behaviors and disrespect for lawful behaviors and getting, yes.
Did you know that Davion's father was charged with murder and arrested, and he's incarcerated in prison for the rest of his life when Davion was just 12 years old?
Overall, you can answer, correct. I believe he told me his father went to prison when he was 11, actually.
Would you consider that to be a traumatic event for a child?
It could be, yes.
It could be.
Yeah.
What about the fact that his youngest brother is also incarcerated? That
It's a pattern of behavior.
Overall, you can answer. Go ahead.
could that also be traumatic?
It could be.
It could be a pattern of behavior, y'all. Psychological disorder. It really can, because everybody in it allegedly in the Murphy family on one side, I don't know, one side from the other side, behavior have a behavior pattern to do something to get incarcerated. They incarcerated, y'all. That's when I said that you can set your own mind setting of which way you want to go in life. You don't have to follow. You can break the pattern, the negative pattern, and turn it into positive, so you won't go that way.
What about being shot in a drive-by shooting? Would that be traumatic?
Overall, you can answer yes.
That
Mm-hmm.
would be a traumatic event.
Maybe yes.
Watching or learning about your friends being shot and killed, family members being shot and killed, that would also be traumatic, right?
Yes, it can be.
How much are you charging the state per hour?
Meridian does the billing. I believe they charge $400 an hour for my time.
You don't have a breakdown of how much you spent on this case or how you billed the state?
No, there have been no bills sent out. Correct.
Okay, Mr. Patrice.
Good morning, Doctor.
Good morning.
Talk to you about Mr. Chance.
Yes.
So you met with Mr. Chance probably what, a little less than 2 hours, you say?
Yes, it was right about 2 hours. Correct.
And about a little over an hour of that was you getting the background that you talked about, correct?
Correct.
Now the testing, and I think you kind of talked about this. This was not, which should not be considered IQ testing. What you did, correct?
Correct.
Do you have any training in diagnosing intellectual disability?
Yes. I don't do IQ testing, but yes, I've done that.
So in your opinion, is you disagree with Dr. Harding's opinions?
Correct.
So is it fair to say that you also disagree with the opinions of the testing?
I can't hear him.
No, I don't disagree with the testing. I don't disagree with the testing.
My apologies, poorly worded question. You disagree with the results of the testing from school?
No, results are results. I don't disagree with results of testing.
Right.
But you disagree with Dr. Harding's results of testing?
I disagree. I have a differing opinion than her opinion with regards to diagnosis. I don't disagree with her testing results. Results are results.
Would you agree that someone with well below average intelligence could be able to do hands-on repetitive jobs?
Yes.
And would you agree that symptoms of ADHD less apparently alike when you're not sitting in school or having to pay attention to different teachers for 6 to 8 hours?
They may be.
Yes.
Would you agree that the inability to hold a job for a long period of time?
I'm sorry, could you ask me that again?
Period of time would be a symptom of ADHD, or could be at least.
It may be.
No, okay. ADHD.
Would you agree that people with
Wow. It's amazing how they making up excuses.
borderline intellectual disabilities?
Yes.
And you talked about Mr. Chance becoming overwhelmed at some point during the interview.
Yes.
Was this around the time that you talked about his children to him?
He did not want to talk about his children, and I left that alone. See, that was another instance. That was a separate instance. Yes, he did become very emotional talking about his children. And so I did not go into as much depth about his children as I normally would, getting their names and ages and that. I did leave that alone out of respect for him because that was yes, he became emotional about that. Correct.
I think you said this, but just to clarify, you would agree that him becoming overwhelmed had a lot to do with the recency of the verdict in this case.
Correct. It was the night before. Yes.
And I think you've been this more in a clinical sense that his being uncooperative, he wasn't aggressive, he just was overwhelmed.
Correct. Yes, absolutely. I felt it was very emotional. Yes. Yeah. It was very raw emotion. Yes.
He talked about his work history with you.
Yes, he did.
Holding a job for very long.
I thought he did with the longshoreman.
Wow. I just found some out.
I thought he did at the longshoreman, but I don't recall.
I think we know this, but he did test his math, his reading, his perceptual reading.
Correct. Correct. Except for with regards to, as I said, in the mental status examination as we went through that. Correct.
Did you leave the possibility out for what we call reversible anger? Appearing, trying to appear smarter than they are? Would that be one of the reasons for using bigger words?
No, as I said, I think, certainly I consider all of that, but he was using the words appropriately in conversation. The way that you and I are conversing, he was using that vocabulary appropriately throughout the interview. It wasn't kind of interjected here and there in that manner to try to impress me or do you know what this word means? One time he said, do you know what the word ostentatious means? And I said, yes. And he said, that's me. That's how I describe myself. I love myself. But he only did that one time. Other than that, the words were normally interspersed in his conversation from him with the same vocabulary interspersed in the writings to the court.
You talked about his behavior during the trial. I think you would agree that you don't know what's going. None of us know what's going on in his head during the trial, what he's thinking about, what he's not thinking about.
Correct.
All right. You don't know, obviously, conversations that myself or any other team are having with him during the trial. That you see us talking, you don't know what we're talking about.
Correct.
So would you agree you can't say that he's fully paying attention if you just believe that he hears that way?
Correct.
Just may I have a moment?
Yes.
Mm-mm.
Okay, redirect.
Doctor, this is specifically as to defendant Chance. So, when you conducted your interview, when you met with him in Williamsburg County Jail through Zoom, yes, this is less than 24 hours after he has been convicted of capital murder, first degree murder, right?
Correct.
And the jail is only providing a 3-hour window for your evaluation. Is that right?
That's correct.
Same with Mr. Murphy.
That's correct.
And that's by their rules and regulations, right?
That's correct.
And by law, you don't have access to the defendant before conviction, right?
That's correct.
And
Mr. Chance and his conversations and the vocabulary. Was this something that was occurring, him using those words and those different vocabulary words that stood out to you in the middle of conversation as he was speaking, just fluidly speaking?
Yes, that's correct. Yes, so I had to go back through my notes and take those sentences out of his interview with me because it was fluently interspersed throughout the interview.
And it looked like words that he was comfortable using.
Absolutely, they were appropriately used in the correct conversation.
And they were appropriate to the context in which he was using them.
Yes, that's correct.
Now, you mentioned the writing that he had written to the court, and you reviewed that.
Yes, that's correct.
Do you recall him using the term hypothetical supposition?
Yes.
And arbitrary inconspicuous theories?
Yes.
Substantiating action of surreptitious immorality?
Yes.
Trying to be grown.
Extrinsic information. Remember that wording?
Correct.
With no on its face corroboration.
Correct.
No prima facie cooperation of corroboration.
Yes.
And again, do you recall him using the term a plethora or a plethora, of public figures?
Yes.
So it wasn't just in your conversation with him, it was in a separate writing before you ever had contact with him.
Correct.
Now, when you're determining intellectual ability, you're not testing like these psychologists did. You're not administering IQ testing. That's not what you did here.
Correct. So I utilize psychologists IQ testing, but then do the adaptive functioning portion of it.
Okay. And you've been doing and conducting these types of evaluations for decades, right?
Correct.
And probably thousands, if not tens of thousands of people.
Yes, correct.
So you have a lot of training and experience.
Yes, sir.
And are you trained in both your residency and fellowships in psychiatry and forensic psychiatry?
That's correct.
Do you meet with patients during that time period?
Yes.
Is that what you were doing at the hospital associated with Yale University?
Yes, that's correct.
And you were asked, this is for both these defendants, because you were asked by both these attorneys about observations and ADHD. You are trained and familiar with manifestations in adults who have ADHD?
Yes, sir.
And is it something that would stand out to you? You would see it?
Yes.
And you haven't seen that in these defendants? Well, I can rephrase. Have you seen it in these defendants?
I haven't noticed it in anything that I have reviewed or been able to observe. Correct.
Would that also involve video and other evidence from the case itself, the investigation?
Correct.
I want to talk to you real quick about Davion Murphy's employment history. Counsel had asked you about him being a dishwasher. Do you recall that being a Cracker Barrel?
Correct.
And he worked there for approximately 8 months?
Correct.
Okay, y'all, what I'm going to do, I'm not going to deal with this prosecutor.
Now, at International House of Pancakes and Steak and Shake, which he worked at.
What I'm going to do, y'all, I'm going to have to skip this. I can't do this. So I'm going to go right here. Right. Let's go right here. Let's go right here. Cause that the prosecutor put me to sleep. I'm trying to hang on. So let's do this. Start right here, y'all. I already took my nap, and no way in the world I'm supposed to be feeling sleepy now. And I win by focus. And neither here nor me because I could barely get
Good.
them.
Everyone have a seat. Welcome back. All right.
Like somebody keep turning the volume down on my computer.
These defendants, they all sit over here at this L-shaped table. Last week, 12 of you went back there, and you came back with and they sit there in their guilt. They are convicted conspirators, convicted killers. They are convicted murderers. There is no doubt about that. What this is about is an entirely different thing. What you're here to decide today and going in tomorrow, what is, as the state told you, in a team, in a concerted effort with one common goal: murder. Murder, the most evil and the most wicked crime that there is. The taking of another human life. And the evidence in this case has clearly demonstrated to you. I doubt any of you had any issue out there internally for deliberating that this was a premeditated crime. The court is going to instruct you tomorrow when you go out after all the closing statements. She's going to read to you again the law on premeditation. And you remember that law from last week. You remember it? There has to be enough time to allow reflection of premeditation. Clearly, in your verdicts, I found that. You would not have convicted them of conspiracy because you can't conspire. You can't have four people conspiring without premeditation. Was there premeditation in this case? Yes. But there was much, much more than just simple premeditation. Because when we talk about reflections, what are we talking about? Reflecting, having time to reflect. We're talking about decision making. Making a decision and acting upon that decision. That is reflecting. Solving a problem. That is reflecting. These defendants, in this case, did this for over 2 weeks at least, making decisions, solving problems, working through their plan. This is much more than simple premeditation. Premeditation can occur in a matter of moments. Let's look at the evidence of the height by plan. They're already conspired, already teaming up to snatch Charles Jones' life from him. June 6th. Do you recall this? The X Spaces discussion that was going on between Isaiah Chance and the victim in this case, Charles Jones. And what happens after that communication between them? That's what happens. Sean Gathride's phone has communication from his co-defendant Rashad Murphy's phone at approximately 11:18 hours. Shortly after that recording was obtained by the Jacksonville Sheriff's Office at 22:36 hours of Isaiah Chance arguing with Charles Jones. You remember his words? Hey, Julio, how's your foot doing? Make sure, this is out of Rashad Murphy's mouth. Make sure, brah, in a good headspace before he go with his move. We got bigger shit to tend to. They ain't worth an inward energy right
That's directed at who? That's directed at his team, Sean Gaffray. And what does Mr. Gaffray do? 17 days before this murder happens, he likes that. He likes it. And then he replies, I ain't heard from bro today, but I'm going to check in with him. And then Rashad Murphy texts back, he's probably not going to pick up. He on IG letting these N-words get him out of character. Turned up on that MF right now. And then Mr. Gathright. Damn, let me see what's up. So what does that tell us? That tells us that the plan was already in place more than 17 years before. This plan had been birthed, hatched, and formulated before June 6th. Before June 6th. This conspiracy and this premeditation spoke to a much higher level of premeditation. It spoke to a very, very cold-blooded motive, a plan, execution. As Miss Doherty told you last week, this was a hit. This was a hit. This kind of advanced planning, where that evil and that type of wickedness to take someone is dwelling in a person's heart, and in this case, a team of people. Problem solving, making decisions about it, working their way through this, developing the plan as they go along. A plan to not just murder, but if necessary, inflict carnage. And we saw that in the evidence. They were going to take out 6, and they were going to take out whoever might be there that might be in 6, because why not? And anyone else standing around, anyone else that might get in the way, that's just collateral damage. Now, why is the state going back to the facts with you? Because in the aggravating factors that you're going to be instructed on in this case, we are relying on that evidence. We are relying, as you saw, solely on our evidence from the guilt phase of this trial. Now, we did present some evidence. That evidence goes to rebut their suggestions of mental health mitigation, which you have seen have completely been rebutted and completely disproven. It is because of the extremely heightened level of premeditation in this case that the state, is presenting you with the aggravating factor, one that the law speaks to, of very cold-blooded murders. The aggravating factor of cold, calculated, and premeditated. That this murder was committed in a cold, calculated, and premeditated manner without any pretense of moral justification. That is the aggravating factor. We see in that evidence, the X spaces evidence, we see that evidence. We see conspiracy. Nothing gets in the way. I'm going to talk and walk back through the evidence of these cases. Let's take a look at what occurred. Mr. Murphy with his fully automatic Glock.
Oh, that's crazy.
And I'm going to come back to that because there's a few things I'll be pointing out to you in this evidence. It's very rare, folks, that an execution is caught on video like this.
Right.
Look at the teamwork.
Look.
Look at the precision. Look at the efficiency.
Gosh.
That evidence alone, standing without the Airbnb evidence of no one going through the front door, without all the other evidence, the evidence of Mr. Chance, Mr. Gathright, coolly, calmly,
Jesus.
like loading up that Impala. Without any of that evidence, you could look at this alone. Common sense would be screaming at you that this is the product, this type of murder, it's the product of heightened premeditation. That doesn't happen without conspiratorial premeditation, planning, wearing disguises to cover their identities, and not just disguises, folks. They're wearing all black to hide the darkness, to hide their skin, to hide their faces. They're wearing hoodies. These are disguises. These are items that they brought with them as part of this plan. This evidence and the efficiency, the positioning, demonstrates the premeditation and the planning that went into this. And this evidence alone would be sufficient evidence beyond any doubt that this was a product of heightened, cold, calculated, premeditation and murder. The tenacity that occurs here, the lack of hesitation that occurs. This is a fully formed, committed mission that they are on that is immediately executed. As soon as the opportunity presents itself, they come out of the shadows where they're hiding. And we saw Mr. Davion Murphy, who snuck down behind those cars. And you heard me asking these forensic experts, isn't that significant that to hide behind the hood being detected by a very wary victim, someone who had his life almost taken 9 months before in an attempted murder that Mr. Gathright is connected to by physical scientific evidence. A very wary prey that because of their advanced planning, they were not going to allow him to get away. And we saw that in the tenacity of this. How Mr. Gathright continued in a persistent fashion, chasing after the Charger, pumping round into it. And then we didn't even get to Dave Murphy following down behind the cars and unloading down the west side of the hotel. So this is the aggravator. First-degree murder was committed in cold, calculated, premeditated manner without any pretense of moral or legal justification. Cold. Cold means the murder was the product. Calm reflection. Calculated means having a careful plan, a plan that is carefully constructed, prearranged, designed to commit murder. In the instructions that Judge Sisko gave you, she will read to you, and you can see that it's the exact same instruction we got her presentation last week. But below that is her distinguishing this aggravating factor from simple premeditation. The aggravating factor to apply has to have a heightened level of premeditation demonstrated by a substantial period of reflection. A substantial period of reflection. Without any pretense of moral or legal justification. So what does this mean? It simply means that there is no claim of justification or excuse. Even if it was insufficient to reduce the degree of the murder, that it would rebut the otherwise cold, calculated, or premeditated nature of this murder. Folks, there is no way to rebut the premeditated nature of this murder. There's just simply no way. There's way too much evidence of it. It is part of this. It's part and parcel of what we watched on that video. You cannot separate the two. To commit that type of crime would be impossible on the spur of the moment. That crime doesn't just speak of a lack of impulsivity. Remember hearing that term earlier in the last day or two? It doesn't just speak of a lack of impulsivity. It screams that this was extremely planned, that this was a designed mission. Rashad Murphy, let's talk about his participation in this plan. And I'm not going to go back through the amount of evidence that I covered with you. I know that was a long process. The state wanted to give you an overview of this massive case full of evidence because of the just incredible investigative efforts of the Tampa Police Department and the Jacksonville Sheriff's Office in this case. Mr. Murphy obtains the Chevy Cruze, the silver Chevy Cruze. That's his first part of the contribution in this case. The car that's utilized as surveillance and as a spotter car. A car that's outside of the circle. Then Mr. Murphy, on his Airbnb account, sending his ID and reserving that Airbnb. And now we see the teamwork. Right around the same time, within minutes, you remember in the evidence, Isaiah Chance receiving a $390 payment from another gang member, an ATK gang member, J. Breezy, sent to his Mr. Richoff warm cash app. And that payment is made to Airbnb. It's paid. And that is established and that's arranged. We have that done over a day before this murder happens. And then we have this video. If the video of the murder itself doesn't establish how premeditated the plan, you need only look at this video. Because even if you got rid of the X Spaces discussions, and you didn't have earlier in the morning paying of an Airbnb, and you have these two defendants, Mr. Gathright and Mr. Chance, business-like. Look at him. Look at the confidence that Mr. Gathright carries with him. They could very well have been packing to go on a cruise or something, and they are packing up that Impala with high-powered rifles, with ammunition, with disguises, the things, the tools they would need to carry out this mission. That's in the afternoon. That is hours, 20 hours or so before the murder happens. And then when they get to Tampa, and they have to drive, remember, because this conspiracy now is traveling from Jacksonville down here to Tampa. They have to travel for 3 hours to get down here. And they're coordinating. We saw that in the LPR, that both these cars are following and coordinating. Again, showing advanced planning. But when they get here, we see this real-time demonstration of premeditation on the part of Mr. Gathright. And I'm gonna come back to that. Not too long after that, after Mr. Gathright is going through the Airbnb app, utilizing all their filters and searching and trying to find Charles Jones' Airbnb and trying to get an address where he may be, utilizing the description that he's seeing on what's being posted by Mr. Jones. Not too long after that, we get this message from Mr. Murphy. Man, you know, I want it myself. If I could, I would have had so many hopes there. I know somebody can get it from them. Get the B&B from me, gang. They're all trying to find the Airbnb. And then, after the run to the McDonald's, get provisions for this assault team, the surveillance team, and all have a dinner, a late night dinner to make sure they got enough energy. They start coordinating. And remember the evidence. By this point, these two defendants, Mr. Gathright and Mr. Chance, they've already gone down to teasers. They've already cased the teasers. They've already checked it out to get the lay of the land. They start coordinating. Mr. Chance is not using his phone because he's going to use his girlfriend's phone. He doesn't want to use his phone. He doesn't want to be tracked, and he doesn't want to be connected. So they start sharing information. Mr. Gathright stores Miss Andrews' phone's information in his phone and contact. They start sharing locations with each other. Now we're up to 208. They're still communicating with each other, coordinating. We see the coordination. We see Mr. Chance, his contributions starting here in the actual pursuit, the stalking, and the hunting of Charles Jones. He's got teasers. As Miss Doherty told you, he's wearing a hoodie. He's wearing a COVID mask. He's using his girlfriend as kind of a decoy or camouflage so that he's not standing around in the middle of the summer wearing a hoodie and a mask looking suspicious. It's just a young couple walking around in the parking lot. And they are there and they're observing Charles Jones and his friends as they're at teasers. Still communicating. Now they're trying to get Gathright to pick up his phone, maybe trying to FaceTime him, which we learned in the evidence is not collected in CDRs, call detail records, and they're telling him, pick up your effing phone. More coordination through the time that Mr. Jones is leaving. And now he and his entourage have gone to Truth 18, and they're at Truth 18, and they're getting ready to leave from there. And more coordination. Sharing location. So they can follow each other. Which leads us to the hotel. We know from the evidence, and I'm going to come back, and I'm going to specifically address Mr. Gathright, because I know you all have concerns about Mr. Gathright. He's 18 years old. The state's never hid from that fact. Is that a mitigating factor? Absolutely, it's a mitigating factor. It's up to each of you to decide how much weight you want to give that. But we need to look at what Mr. Gathright did. We need to look at how he conducted himself this early morning. Well past loading that Impala. That's Mr. Gathright driving that Impala. Remember, the assault team never would have been able to find that hotel if Mr. Chance and Miss Andrews hadn't followed the victims, stayed just far enough behind and tailing them so they weren't detected, but able to see where they were going and relay that. Because Mr. Gathright, coordinating with his co-conspirator in this extremely premeditated plot, went directly to where the victim and his entourage had already gone. They had already pulled into the Hoka Suites when Mr. Gathright was nowhere to be seen. Mr. Gathright immediately navigates that Impala around the north end of that hotel, passing all of those cars in that parking lot, passing all of the filled parking spots as he went around the north of that complex, around the Holiday Inn, back around to the west side. Now what we see in these photographs is Mr. Gathright navigating that car, making sure to do a three-point turn so he doesn't feel the presence in his car that they have hidden. Now, if you go back to Truth 18, which I kind of skipped over, you remember Mr. Chance, the surveillance team. He gets out with Miss Andrews. They're just a young couple making closer observation and give that intelligence to the strike team, the hit team, the assault team. Mr. Gathrights driving the Impala. He parks across the street, or parks, right next to the strip mall where Truth 18 is. But as they're getting ready to leave, and they're getting information that must have been received, Mr. Gathright repositions across the street. He pulls up to that stop sign. And one thing you may have seen in the evidence, he stops and then he creeps forward so that he can see around that corner and see the entourage, and see the victim's car. You heard Detective Ramos, this detective who did this incredible job and sat on the stand as a true encyclopedia of this case, telling you, and it's his opinion, they were getting ready to possibly try the assault or the follow. But he gets there, and he's also now part of the surveillance. And he's stage waiting. Here in the hotel parking lot, he is taking the precautions. He goes down, and he turns the car around and comes back without going around that corner and breaking the plane or anything else. He goes up around the corner, here he goes past the Tesla, they park. And then you have to think, there's no way they were driving around Tampa in June, hundreds of masks for 4 hours. It starts at around 1 in the morning. This is now 4:30, 3.5 hours. So they had to get up, get their hoodies on, pull these masks or gaiters or whatever they're using to cover their faces. Mr. Gathright has to retrieve that AR-15. Now he's handling it, and they're running, and they're acting as a team. These 3 individuals that are the assault team. And as I said, Rashad Murphy, or Davion Murphy, with his ski mask on, with only eye hole showing, with the 300 blackout, crouched down, making himself unobtrusive, trying to make sure that they conceal their presence. Because this was all predicated and designed around an ambush. And you remember the state telling you in opening statements that they brought fire supremacy? That was part of the plan. That was part of this, to bring overwhelming firepower to this situation, because they weren't going to let Charles Jones get away. Not this time. Not this time. They were going to take him. He was not going back to Jacksonville. He was going to stay here in Tampa. So they bring 3 shooters with high-powered rifles and all of this firepower. In a few minutes, I'm going to talk to you about another aggravating factor that was with that. But I will say to you, that firepower was brought for a specific purpose to ensure anyone else that got shot, it didn't matter. Not a one of them. No hesitation that they were sitting in front of a hotel, a packed parking lot. So now we're up to the point where you're going to commit this assault, and I want you to consider this evidence. I don't want to belabor the point because I think you all understand. I don't think you can consider that there's unprotected. But the law speaks to that reflection element, and it's something you need to take into account. As I said, it's decision making, it's problem solving. And you think about all of the decisions in the problem solving that goes on. Mr. Gathwright's use of the Airbnb app and the VRBO app and that search alone, I'm going to come back to that in a few minutes. That sitting by itself is an overwhelming load of decision and problem solving decision. But think of all the decisions he had to make. Mr. Murphy had to try to coordinate Mr. Rashad Murphy to get that clearance. He had to talk to his sister or his brother's mother, his brother's children, and he had to coordinate with her because someone had to go get the car. Either he had to go pick it up or she had to bring it to him. Every one of these steps required multiple smaller steps and multiple decisions and problem solving. Well, can you drop it off? We'll drive you back. Or can I pick it up from you? And then he's got to get someone to drop him off. And we know he's driving it when he goes to the Walmart and someone there is driving it and they come and pick him up when he comes out of the Walmart the night before. That alone just shows another example of the problem solving, the decision making, and then the back and forth with Airbnb and booking the Airbnb and finding an Airbnb that just happens to be 2 miles from Teasers and ends up being almost a mile and a third, just over a mile from the murder scene. But in that same area right there around Busch Gardens. So now we have our assaulters. These 3 defendants, Mr. Murphy, Mr. Gathright. I kind of want to walk through this with you, and I may have to use this want you to look at where Mr. Murphy's rounds are hitting center left on that windshield. Mr. Murphy, Rashad Murphy, opens up first. He runs out immediately, starts firing with that fully automatic Glock. Puts several rounds tracking up the hood into that windshield. Watch the driver's side of the windshield and the back window of the Altima. Now we're seeing impacts to the driver's side. You can see the glass spraying upwards from the impacts through that automobile windshield glass. And we know Camilla Bentley is in that car on the right, the Altima. She's already got her foot on the brake. Watch when her car starts to move. First impact. Second impact. And we know she takes the 2 rounds to the back of that car. This is efficiency. This is overwhelming firepower. So Mr. Murphy, Rashad Murphy, has stuck his head around the corner and looked. The way that he and Mr. Gathright coordinate, it's almost as if they did a countdown, like a 3, 2, 1 or something. But they come out and they take up their firing positions quickly and efficiently, which shows heightened premeditation. And they're acting immediately. Watch Mr. Gathright. He will not even be in a standing position before he's opening fire. He is running into his position and starting to fire with his feet removed. That's how quickly they wanted to put rounds before anyone could react to them. He's already fired. He's still moving at that point. So look where he's pointing. He's pointing towards the charger. And then you see his muzzle swing to the right. Right there. He's making an intentional decision to redirect his fire after he has put 2 rounds in the windshield of that charger. Now he's redirecting to the Altima, which they thought Tafa McCrae was driving. The 6 block number. But in fact, Camilla Bentley had slid into place. Camilla Bentley was in the back seat. And for some reason, I don't know if you all looked at that when you were deliberating, but it's almost weird the way she slides in behind Tafa as he's getting out, and I believe her testimony to you was, I wanted to take charge. I wanted to get in the front seat. She would have been in that back seat if she hadn't done that. And those 2 rounds were centered through the rear window. I'll talk about that later. Look at the purposeful, intentional behavior of Mr. Gathright here before Mr. Murphy appears up there. It's perfect coordinated. It's hit by the hit, runs into the tree, almost falls down, turns, continues to fire rounds into that car. Now they're both fired into it. Almost perfect timing. Now Mr. Gathright is still firing. Look at where he's firing. He's firing northwest towards that charger. But just look at the tenacity. That is purpose-driven behavior. This was something that they did in their hearts and minds, the point of view for weeks, for days, to murder somebody, take someone's life. And you see this overwhelming firepower. There was no consideration for anyone else in that area. None whatsoever. If they hit some 6 block members, that's all the better. Anyone who else, and this is another thing. When they're coming out of teasers or 318, Mr. Gathright sitting over there at the stop sign. He sees the signs of that entourage. He sees how many people are involved. He knows how many people are in those cars. already pointed this out to you. Look at the accuracy of those rounds to the headrests. Both headrests taking rounds. Sean Gathright shooting an AR-15 chambered in 5.56 NATO. What caliber were the two rounds pulled out of Charles Jones' body? Well, the one round, what was its caliber? It was a 22 caliber class, 5mm class, which is 5.56. The other round, they could not figure out the caliber. Miss Drew couldn't, but she could tell you they had consistent rifling, and they appeared to be the same, from the same type of rifling. Mr. Gathright put two 5.56 round NATO bullets in Charles Jones' body. We don't know about the other bullet to the chest. That could have been from Rashad Murphy. It would make sense. Davion Murphy, look at him crouching down, hurriedly getting into place, running behind those cars, staying concealed. Staying in his hiding place, you remember, in his area where he cannot be seen because he doesn't want to reveal that he's there.
I knew that was Davion.
They try to go somewhere else. They want them to go that direction. They want them to go into that area. And they don't want them to flee or have a chance to get away. And then, again, coming back, Mr. Murphy's tenacity, purpose-driven behavior. He's not giving up. He's not going to stop. And then quickly back to the car.
Wow, Davion. Now how you feel?
Rashad Murphy running back to the car.
Yeah.
The image on the right. If you look at the direction of his head, he's looking towards the fleeing car. His direction is towards Charles Jones' Charger. And you can see in this image he's now moved slightly forward and he's still looking in that direction. All of them were paying attention to what was going on with Charles Jones. Now, we finally get back to Jacksonville the next day. And for the first time in all the evidence, the ghost is revealed. Rashad Murphy, in person, showing up. Rashad Murphy tried to conceal, to try to protect the conspiracy 17 days before when Isaiah Chance was talking to the victim and arguing with him, trying to get him to stop. You don't want to give us up. You don't want them to know what we're up to. You don't want to give them advance notice that something might happen. The ghost, who never appears on the ring camera at the Airbnb in Tampa.
Because it was the ghost.
That takes thoughtful, deliberate action in and of itself. None of these defendants appeared on that ring camera on the 22nd when they get there. They're going in and out of that Airbnb, as Miss Doherty told you. All through that evening, Chance and Gathright are going down to case the teasers earlier in the evening. They're leaving to go. Chance is going with his girlfriend and Mr. Davion Murphy up to the McDonald's to get food, and they never appear until after everything is done. Before I move away from the cold, calculated, premeditated, I want to move back to Isaiah Chance and just kind of cover some of his involvement in this case. We talked about this. He's the one that actually pays through J. Breezy's contributions from the Airbnb. He provides the Glock with the extended magazine that is utilized by Rashad Murphy in the attack. He helps load the Impala. Now we see the photographs of him on the left. That teaser's on the right in Truth 18 with Miss Andrews providing the essential, critical, on-the-ground, real-time intelligence and reconnaissance back to the assault team. There's no way, as I said earlier, that Mr. Gathright would have been able to find where the victim went. unless he was right on their tail revealing himself. The only way he knew to do it was because Mr. Chance told him. And when they needed him to come in for last second reconnaissance, remember how fast after he had staged across the street at the Embassy Suites there at USF, he comes flying back across Fowler, blows that red light, and pulls right in and drives right past the victim in the car that they all know not to recognize. That's why Mr. Rashad Murphy had to solve that problem and go get that car. And now Mr. Chance is providing last second intelligence to the assault team. So he drives in, drives past, goes around the corner, encounters the Impala, goes right past it, does that three-point turn, and then he comes back. This is him still going, and then this is him coming back. And we know in the evidence this is less than a minute before the attack occurs. That didn't happen for no reason. That was a coordinated effort. And without Mr. Chance's information and intelligence to them, they wouldn't have known for a fact where Charles Jones was sitting. If you look at the passenger side of that Charger, you can see Mr. Jones' red and white socks up there on the dashboard. I don't know if you saw it when you were deliberating last week, but when the attack occurred, you quickly see his feet drop down as he's trying to scramble into the back seat to save himself. But clearly, they were there for a purpose, and that was to tell the assault team exactly where Charles Jones was. When you're considering Mr. Chance and Mr. Gathright, you need to consider their contributions to this murder and their role they played in this murder. Without these two defendants, this never would have happened. It never would have happened. Without Mr. Chance providing that real-time intelligence, they would not have been able to track Charles Jones. They would not have been able to orchestrate this attack. Mr. Gathright, we know that the attack, this whole thing that day starts where? It starts at the Gathright household. In the Gathright household out in the suburbs of Jacksonville. And again, we see this extremely confident defendant, Mr. Gathright, loaded for bear, loading up his car as if they're going on a vacation, just as casual as can be without a care. He and Mr. Chance are discussing how they're going to load it, where they're going to put the items, more problem solving, more decision making. Back and forth. And of course, we know from the evidence, from the search warrant that was conducted at the Gathright residence, that Mr. Gathright was the armorer of this assault team. He was the weapons man.
Controller.
He provided the armament that was utilized. Beyond Murphy. That rifle being utilized by Mr. Gathright. Office of tenacious, goal-oriented, purpose-driven behavior by this defendant. And what was the whole purpose of this? Was he looking for an Airbnb? Was he looking to rent a property? Was he doing anything of any kind of productivity? No. He's trying to find their prey. He's trying to find Charles Jones, their target. Desperately trying to find him. Actively trying to find him. That phone's not moving itself. That's its fingers doing that. Searching, looking. Now the filtering. you're comparing it and weighing it against a significant mitigator that was 18, this is that this was in cold, calculated, and premeditated murder. Remember, it's an individual sense. But because this is a conspiracy, because they have this team, a lot of this evidence, you got to look at it as a whole. You got to look at it as a whole. Every one of them, this cold, calculated, premeditated aggravator applies to each of them. This alone, this is enough premeditation to convict 1,000 people of first-degree premeditated murder. But it doesn't end there, because at 1:30, this defendant is not done hunting and searching for Mr. Jones. Now he's going to utilize a technique, a honeypot. He's going to use a honeypot technique, if you've ever heard of that term. A honeypot, a lure. He's going to try to lure and get that information by luring it out of someone, by using this pretty young girl, Kyla. Unbelievably goes along with this. I need you to text Fat Boy. You would never know who Fat Boy is. It's probably words. About what? Because I need you to text Fat Boy and tell him you're trying to pull up about trying to see him tonight. You know I'm gone. I've been FaceTiming him while I'm out. She doesn't really understand at first. He's in Tampa right now. Make it seem like he's there. He had a B&B with 6. Be like, what's YA? WYA? Where are you at? I want to pull up. I'm drunk, trying to F. Never mind. Then she says we had here in the club. She's not following. You want to come to the B&B with us? Question mark. She's not understanding. No, I'm in Tampa. I'm trying to see where his B&B at. No B&B. 6. Fools. It's his B-Day in Fat Boy Widow. Not here in Jacksonville. No, they in Tampa. Why? She still doesn't understand. But they have to stop. They have to persist. Let me FaceTime. Play like you know it. Fat Boy going to Beezer's tonight or some shit like that. Clearly, this defendant was persistent in tenacious in his attempt to locate Charles Jones. And then we know that in addition to all of this effort and involvement in this case, because folks, the evidence in this case shows there is no defendant sitting over here. There is no defendant in this case who did more to orchestrate this murder than Mr. Gathright. They may be as involved in him, but nobody exceeds his culpability in this murder. He adds and provides the car for the assault team, the Impala. He drives all the way down there and takes the entire intelligence and surveillance team with him. We talked about this, how he drove around the parking lot, how he maneuvered.
Wow.
How he maneuvered and kept the assault team from being detected. That's on that defendant's shoulders in this cold, calculated, premeditated murder. And where does this whole thing end? At the Gathright residence in the suburbs of Jackson.
And Alicia had to know about it.
No, this defendant's not there. He's over in Auburndale in Polk County, dropping the Impala off with his unsuspecting grandmother, leaving it with his grandmother, Miss Allen, and then driving off in her 4Runner, now loaded with all of that ammunition and all that other evidence. this evidence alone, this aggravated that, that no other aggravated would justify each one of these standing alone, because this is a boatload of premeditation. This is, like I said, it's enough premeditation to convict thousands of men. There could have been 40 people participating that each had just a little chunk of this 2 weeks. Or than 2 weeks of premeditation. And they all could have been convicted as principals. First degree murder. It's overflowing. Trial. All the way up to the end. More and more and more evidence. More and more evidence. In football, it's called piling on. Should have occurred. Because we're of something that we need to prove it beyond a reasonable doubt. But like I told you, zero doubt in this case that they can be found out when you went back. This aggravating factor, it stands on a substantial volume of premeditation, of evidence of premeditation, of heightened premeditation. This aggravating circumstance alone justifies presence of death. This aggravating factor alone in its evil and its wicked nature outweighs any of the suggested mitigation for any of these defendants. Any of them. They conspired, they premeditated as a team, and it applies to each one of them. This aggravator that even shot Murphy, Sean Gabriel, or Davion Murphy was contemporaneously convicted of a felony involving the use or threat of violence to another person. You can take out the previously part. That's another way of proving that. They were convicted of a contemporaneous violent felony. When you all came back here with that just verdict finding them, these 3 defendants guilty each of 3 counts, not 1, but 3 counts of attempted second-degree murder. And that's exactly what they did. Attempted second-degree murder. That is an aggravating factor that I've kind of broached and talked about a little bit already. They weren't going to just kill Charles Jones. He was the target, no doubt about it. But if there was someone else there, 6 block, they were going to kill him.
Right.
You saw that in the evidence. So let's talk about each of the people who were affected in those counts. Victim, Gino Norris, 22 years old, not a 6 block member, but a lifetime friend or a lifelong friend of Charles Jones since they were in middle school. He was there to celebrate with Charles. This young man that you saw come in here, this man talked in low tones, in a subdued voice. You saw in the evidence when they went up the stairs at Truth 18, he kind of paused and leaned on the banister and waited for everyone else. He was there because he was Charles Jones' friend, not because he was a member of 6 block. But that didn't stop him from catching a round in his arm. Xavier Edwards, the driver of the car, who is a 6 block member, 19 years old at the time, he took multiple rounds into his shoulder. He had grazing wounds on his hands, probably because his hands were up where all of the glass was shattering on the steering wheel. This young man most likely saved not only himself, but Gino Norris's life by pressing down on that accelerator and driving through that massive wall of fire.
Good job, buddy.
Between Davion Murphy and Sean Gathrigh's high-powered rifle fire. then this photograph, because I want to speak about this a little bit. We're going to talk about it. Look at their faces. Look at that. That's a body work. That's not a pose. That's an image of what's occurring. That's a screenshot of the body work. Look at the stunned look on Gino's face. And look at the expression on Xavier Edwards. We heard testimony this week about this was a traumatic event. Heard that? By a criminal gang member. Now, I think Mr. Treatise had come up here in his opening and had told you what you all already know. You already have found that this the wording that you were given, and that's a sentencing enhancement, is that the crimes were committed by a gang member or associate. Because both of those would qualify. You remember the gang detectives talking about the criteria numbers that have to be met in the Florida statutes for a gang member or for an associate. The state has no doubt that when you deliberated, you found that all of these defendants, other than Mr. Gathright, are gang members. But now you will have to make a finding from them. The state has proven beyond any doubt that they are. You will be given the same instructions about the criteria and that so many have to be met. Is that an aggravating factor in this case? So I want to ask you about that. Does common sense say that it is? Because if one of these defendants who was a gang member, let's just take Mr. Chance, just as an example, if he had got into a fight with his girlfriend, found out something about her that he was upset about, he went out to his car and retrieved the gun, he loaded it, and he walked around the block and cooled off and came back and decided he was going to kill her anyways. And he went and murdered her. That would be premeditated murder. And that would be an aggravating factor because he's a gang member. But in that instance, the gang membership would have nothing to do with that. It would be unrelated to that murder. And it'd still be an aggravating factor. But here, this is the heart of this murder. It's the heart of this plot, this plan. All four of these defendants share the same motive to take out Charles Jones because he is in the opposition. Mr. Gathright, we don't have this aggravated case, but we clearly have allegiances and associations. So it goes to the CCP, the cold, calculated, premeditated aggravator as far as Mr. Gathright. His motive would be relevant to that to show the height of premeditation. But it against him, you cannot consider as such. But these other defendants, yes, it's not only an aggravating factor, it's an essential part of the cold, calculated, premeditated manner that the murder was committed in because it's their motive. It lays at the heart of this case, and that's what makes it so aggravating. You couple that, that the reason they're doing this is because they are criminal gang members.
Right.
And they're taking out an opposition criminal gang member. That's what aggravates this murder. And it applies to these three defendants, the Murphys, and now Mr. Chance. Not Mr. Gathright. And we know what their motive was. We can take it right out of Young and Ace's song that was written and produced and uploaded just a few days after Charles Jones.
Wow.
Davion Murphy, Shug Spaz. Davion Murphy, throwing gang signs. Talk about cold blood. They're talking to him about a murder, and he's in there throwing gang signs when they leave him alone. This is a proud gang member. He is a walking billboard of it's indelibly imprinted all over his body, from the 1200 on the back of his neck and his upper traps, all over his body, with the members of the murdered or killed. Rashad Murphy. out the next day. It was barely afternoon, and he's posting his motive in this murder, throwing props to Prosper, Junior, Get Back Day. They are the 187 babies. And we all remember what 187 stands for, right? California statute of murder.
187
On this
babies.
slide, you see Mr. Murphy. We saw still shots of Mr. Murphy there. He's throwing an upside down 6 and a fully down sign. And those videos that he was in with numerous other gang members, including Wapa and Spinabins.
The oldest one in there. Mm.
And then Mr. Chance up on the top left.
Let me see. Gutter.
Rights photos, and they're only to show that he is associated with as a house agent. Again, cannot consider this an aggravating factor.
All right, y'all. Let me see. Let me speed it up. Let me speed it up some. Let me speed it up because we already know all of this. Let me speed it up a little bit more. Right here.
Just like that, this evidence shines brightly. It can't be avoided. It can't be hidden from. No hoodie, no COVID masks are going to hide the defendants from this aggravation. There are no Ubers here to whisk anyone away from your sentence in this case. There is a mountain of evidence proving these aggravated factors. I point that out to you because it gives you each of this go back there and you're delivering, you're voting on what the appropriate sentence is for each one of these defendants. It gives you the assurance, it gives each of you the knowledge deep down that your sentence is based upon not just a rock, it says in the scriptures, not just a rock. It's based and it sits on this giant, enormous mountain of evidence of premeditation, evidence of creating great risk to many people, and the gang membership that lies at the heart of this case. All of these aggravators, there are mountains and heaps of evidence that prove it. None of you should walk out of here after you enter your sentences and your votes. None of you should have any qualms or doubts about doing so, because you can go home and you'll know that night in your heart that your vote to sentence these defendants to death, your vote stands on that evidence and that assurance. You can have that assurance that night. You can be assured of the correctness and the justness of that sentence of death the next day, through the weekend, into next week, into next month. For the rest of your lives, you can know that your sentences in this case are just and right sentences. I quoted earlier from the book, Kalamaki, describing another writer, a writer from the 19th century, from the 1800s, Robert Louis Stevenson, wrote those wonderful books, Treasure Island, Mistake, Dr. Jekyll and Mr. Hyde, stories that we've all heard in our lives. He was a great writer. He was a poet. He was a national hero in Scotland and still revered there today. But he's also known for this quote: eventually, everybody sits down to a banquet of kindness. consequences. And today, each of these defendants, almost, were sitting in this courtroom from their The state of Florida stands before you and requests that each and every one of you go back and vote to sentence each of these defendants to death for the
Excuse me.
murder of this man, that you sentence each of them to death, knowing that it is the just and it is the right sentence in this case.
He want them to death, boy.
Ladies and gentlemen, jury, it is 4:37.
All right, y'all, let's talk about it. Okay, let me put it back on their little innocent faces. Let me put it back right here. Okay. Let me put it on, boys. All right, y'all, let's talk about it. Let's react. Let's react. Let's talk about this now. Let me put it right here. Yeah, you.
I run a podcast. I get high quality podcast recordings right from
All
my
right,
brain, and I'm not
Riverside.
using
Okay, get your
Watch
connection.
this. Riverside turns my recording into social clips automatically. It even creates thumbnails and writes the description.
Okay, yeah, let's talk about it. Let's react to this. Tell you. Put it back on Sean face. Put it back on Sean face. You know. Then put face. Let's get back. Let's get back. Okay. I want to keep it right there for a minute. Okay. Yeah. I already said a lot from the beginning. Hold on, y'all. Oh Lord, it may cut off. Okay, no, it's not. No, it's not. All right, y'all. Let me go back and look at my notes. What I took over. Okay. All right, y'all. I said welcome. I said thanks for watching. Like, share, and subscribe to the channel. Forensics evaluation is not confidential. We have a behavior psychologist came up aboard to talk to the court. Well, let me get Sean popping his neck. Hold on, let me put him in another position. Okay. And she said a couple of behavior spoke on each one of them. Davion behavior, and we already discussed that from the beginning. Um, this is what they choose to do, y'all. Davion said he loves his family, so you know he was straight. Davion denied physical abuse. He was okay. And I was saying that I had mentioned that to y'all, and I told y'all nothing was wrong with them from the get go. Isaiah Chance, attorney, said he was well below average ADHD behavior. He has when he was a kid as well. They made excuses for their behavior for what they did to Julio Foolio, which then it's if they had all of this wrong with them, they wouldn't have act like that. Isaiah is 20. This is what I did for the ages now, y'all. Isaiah 23, Sean 20, Rashad 32, and Davion 29. How in the devil did Sean get mixed up with Isaiah? Isaiah and Sean is friends. And it ain't that Sean allegedly was trying to Sean and Isaiah allegedly were trying to be like ATK. I can't think of the boy name, but him. You know what I'm talking about. Okay, this was they was convicted of first degree murder and conspiracy, aggravated factor, which is evil. Uh this the prosecutor was mentioning that this was in attempted second degree murder. And then he went out, he named some of the victims that was shot. I didn't get the girl name, but Gino was when he was 22. Uh, he was shot. He was a friend of Julio Foolio. And Xavier was when he was 19. These dudes was the same age as these characters who shot them. Okay. The prosecutor also said that the first degree murder was committed by a criminal gang member. And he had months of evidence. Y'all, I'm not gonna make up no excuses for what these boys did. These young men choose to do what they did, and they need to be punished for it. No if and no buts. And nothing else I can say about this. That I'm glad that Julio mother is getting justice for her son and all anybody in this case that was um, wounded in this case. Even we had people that didn't get shot and they were shooting at the hotel. I mean, it ain't nothing else to say, y'all. They don't need to be transferred. They need to be right there. If they gonna work, they need to be right there in that same place. And I didn't even know. Oh yeah, that's what I want to mention. I didn't even know that Isaiah had kids. What? You got kids? Don't you know when you start having kids, y'all, things, your life changes. Yes, it does. It's not all about you no more. It's about your kids. You and your kids. Your health and your kids. I can't believe that. I really can't believe that Isaiah had kids. I mean, this really touched my heart so much like they weren't raised. I can't say they weren't raised right. I just don't understand, y'all. People but just having children, bringing children on this planet, and it's not prepared for the consequences and the choices and decisions that they have to make to be parents. When you become a parent, you ain't got time to be running behind on games. You got to work and take care of your responsibility. Each young man is accountable, has been accountable, has been convicted. But I don't want them to get second degree murder. I want them to get first. Where you going, man? Go sit down. Y'all, these dogs about there. Got to take them outside right quick. So they ain't gonna mess up my flow. But I want to tell y'all, go in the house. Excuse me, y'all. Go in the house a minute until I get off this phone. Till I get off this don't got me nerve. Don't have me nerve. Yeah, I can't mark no more. I can't do all this stuff no more. These bones ain't strong. Woo wee. But I want to tell y'all, thank you. thank you for hanging with me from the beginning to the end. And if a lot of y'all just came in the middle, I want to appreciate y'all hanging in there, y'all. Thank you for hanging in there, because I'm telling you, this was tough keeping the eyes open. So, y'all, when they what's gonna happen tomorrow, I will let y'all know. And I just want to say thank you, and I appreciate you all for being here, watching this with me, listening to my reactions. And it's for y'all. I do this for us, because I love y'all. Y'all my new family now. Y'all my new YouTube family. And I have to stay, even though I retired working with kids in from K to 12, in health education, y'all, physical education and health education. So it ain't no proper language speaking to them kids in no gym. Just get down. What the heck are you doing? Yeah, don't do that. Well, it's other than that, I'm still here for them. I'm still here for the young people and the parents. Young people and the parents. I'm still here for you. I want to thank y'all for being here. Like, share, and subscribe to the channel. Keep it real. Stay real. Be real. I'm out of here.